Welcome to Win with the Law with your host, Gary Newland. In the Win with the Law podcast, your host, Gary Newland, partner at Newland & Newland LLP, invites guests who are experts in the personal injury law arena and other areas of law of interest to discuss topics relevant to the general public. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, newlandlaw.com. Now here's the host of Win with the Law, Gary Newland.
Welcome to Win with the Law. Today we have a very interesting topic. One of the areas of law we're going to cover today deals with domestic battery, and we'll talk about some other areas as well. We're fortunate to have with us here today Arnold Pula and Paul Koontz. These gentlemen are with the renowned Hirsch Law Group, one of the most respected criminal law firms in the Chicago area. At this time, without further ado, I'd like to introduce Arnold. Arnold, can you tell us a little bit about yourself, and then we'll go to Paul.
So my name's Arnold. Prior to working in criminal defense, I worked as a prosecutor in Cook County for 3 years. I've dealt with a variety of cases. I've specialized in domestic violence cases. I handled them as a prosecutor, and now on the defense side, by being a prosecutor, I've learned a lot and learned really what the state is investigating, how their investigation works, and what the side of the prosecution does, which really helps as a defense lawyer.
And Paul, can you tell us a little bit about your background?
Sure. I started off back in 2014 as an ASA in Winnebago County, which is the Rockford area. Then since then, I've been doing defense work, Winnebago County, Lake County, Kane County, DuPage County, Kankakee County, a lot of counties, running the gambit from domestic violence, traffic tickets to, murders, drug-induced homicides, things like that.
Wow. Well, we got some very experienced attorneys here today, and I guess why don't we start with and maybe we'll start with Arnold. If you could help us understand what is the difference between domestic battery and regular battery?
Do you want me to take that one, Arnold? Or
I can take it. It's okay. So when there's a domestic battery, there's a family or household relationship. So usually it could be spouses, brother and sister, boyfriend, girlfriend, any type of domestic relationship. Then it'll be a domestic battery. A regular battery usually occurs between individuals that don't know each other. For example, two people that are at a park get into an escalation with each other and one decides to punch the other one, or you get into a road rage with someone and you decide to get out of the car and punch someone. That's a battery. And then if it's you hitting your spouse, then it's a domestic battery.
Well, Paul, let me ask you. So why does domestic battery have its own class of law?
Well, because the state and the legislature saw it fit that when you do have a familial relationship, whether it be husband, wife, boyfriend, girlfriend, kid, stepchild, anything like that, there's a far greater personal nature to it. And the potential consequences in the eyes of the law can be more, difficult to navigate when you're dealing with all of those emotions and history and the facts that, you might not necessarily find in a simple battery. Like per Arnold's example, if I got into a road rage incident and I punched the guy on the Dan Ryan because he, was going too slow, I've never met the guy. I don't know the guy. I just, got mad and punched him. Whereas you have familial relationships, somebody I've been dating for 4 years, you have the background. You have the differing point of views. You have that emotional aspect of it. So it was needed and deserved for them to actually spell it out specifically as its own offense, as its own area. And it's with its own penalties, with its own nuances, everything like that, beyond just what would be punching the guy on the street.
So for either of you, gentlemen, it's my understanding, and if I'm wrong, enlighten me, but the consequences for domestic battery can be more significant than for regular battery. So I don't understand why that is.
So the reason they looked at that is, the easiest distinction between the two, and the simplest terms of, so on a simple battery, it's supervision eligible in Illinois. It's still a Class A misdemeanor, but you can be given supervision for it. So after your term of supervision, if you complete, any anger management or any other condition that the state puts on, it gets dismissed. Whereas domestic battery, it doesn't. There is no supervision. It's not supervision eligible, meaning that it's going to be there. That if somebody pleads to or is found guilty of domestic battery, it would always be a conviction, and that would always follow them as well. And again, they're taking into account the relationship nature of the situation, and the prior history, the emotion of it, and I can get into this a little bit later, but the state takes prosecutors, they take a look at a domestic battery situation, right? And then if somebody comes back later and recants, the state often takes the view that that person is being coerced somehow. That person is, when the complaint was made, that's the actual situation. So they take on this posture of having to, defend the person against themselves in a way.
So it seems to me that, so in a regular battery case, the people don't really know each other, but in a domestic battery, let's say husband or wife or child parent, or let's say two lovers, the abuser may have the ability to intimidate the person much easier in terms of not coming forward and testifying. Is that true?
That is very true. And it also goes along the lines of, again, we can talk about this later, but it runs the lines of somebody may just have made a false statement. Maybe things got heated out of hand, right? But again, the state takes the opinion of it that it's like they need to protect the individual because they don't want to be the person that said, okay, we allowed the charges to be dropped in this situation, and then something, horrible happens to that individual, after, the case is done. So,
I think, what's interesting is OJ passed away. Was that today or yesterday?
Yesterday, I think it was.
Yesterday. And I think there was domestic battery issues related to that. And I think what happens is oftentimes domestic battery leads to worse crimes too. Is that I've heard statistically that's a possibility. Is that anything either of you are aware of?
Yeah, usually a lot of murders do happen from domestic related incidents. They start from something small like a push or shove, berating each other, saying things to each other that are at sometimes a little crazy, and then it escalates. It starts from that, and then it ends up to being someone being choked, and then from choking, even more, ultimately to points where a partner can go and shoot someone else. That's why also another penalty that the state adds for domestic battery, if you have a domestic battery conviction, they can upgrade it to a felony if you do get charged a second time. That's why domestic battery is very serious, and it is often charged as a misdemeanor, but if you do get a conviction for a domestic battery, you could, on a second time, be facing felony charges, which face where you'll face serious penalties.
So let's break this down if we can. So on a regular battery, if you're involved with a battery of a stranger, you may be entitled to supervision. Is that fair?
Correct.
Yes.
Yeah.
And the supervision is expungible, so the person could have it wiped off their record if they don't get in trouble again for a while, right?
That is accurate,
Yeah.
yes.
So then, but if you're charged with domestic battery, they're not allowed to give you supervision under the domestic battery statute, correct?
The charge would have to be amended to a simple battery. And then a lot of states' attorneys' offices have policies. For example, in Cook County, the victim has to be open to the charge being amended. You cannot amend the charge without the approval of the victim. So it can be tough in situations.
So so then what you're also saying is a second offense can result in an upgrade of a felony when it comes to domestic battery, correct?
It is possible, yes.
Yeah.
The prosecutors during the felony review process will review the facts and see what happened. If it's something like a slap or a push the second time, then they might not upgrade it to a felony. But if it's something more serious, if the violent acts escalate and get worse, then they could charge it as a felony. And then also another way is if the abuser strangles the victim. That's another way where it could be upgraded to a felony.
Now, at the Hirsch Law Group, is this something that you deal with commonly?
Yes.
Yes, we do.
And is this? I think most courthouses have a separate room or rooms for just domestic battery alone. Is that right?
It depends on the county.
Okay.
So the larger ones, they do. I mean, Cook has its own entire building to cover that. But then again, some of the the collar districts, they could hear DV cases as well. And that's what DV is, domestic violence. Then some of the smaller counties, they just really don't have the volume or the ability to have a designated specific courtroom for it. So
So it's interesting because I do personal injury work, and outside one of the personal injury rooms in the third district was is there? It's still there. It's a domestic battery room, and I've been going to that courthouse and those courtrooms for years, and so have many of the people that are involved in the domestic battery room. It seems like there's a lot of repeat people in that room.
that is, that it is very much a slippery slope. And again, I think that's also why the legislature found it necessary to put the onus on domestic violence as they did, because oftentimes those individuals, they don't cut ties afterwards. There's a lot of relationships staying together after the fact, and nothing changes, so it happens again and again. And it's again, it is a very slippery slope to a very high felony.
And it seems like,
And it's hard
a
for
lot of
people to
times the
cut
victims
ties.
are repeat victims, even with different men, and the men are repeat offenders because it's usually men when it comes to different women, even from what I can see just from being in the room next door. But what I was wondering was, what do you do when someone comes in and says, "Hey, I'm charged with domestic battery," and I'm the woman? Does that change anything?
No, at least in my eyes, it doesn't, because, and unfortunately, there is, and I dealt with it actually this morning. There is this idea that you women are less likely to commit domestic violence. I think that's societal view of it. But at the same time, I've seen situations where the women have just, or one part, they've just beaten the crap out of their partner, and or their child or something like that, and it that old axiom doesn't hold true. And I've run in situations where clients have been beaten up by their significant other, sometimes female, and the male partner who's getting beaten up will get arrested on the assumption that they must have done something to instigate the domestic violence. And unfortunately, just because you're a woman or a man, it doesn't. You can still commit domestic violence. I mean, it's. But that would vary by county. For instance, Cook County, the tolerance is women, can also do it. But if you go into one of the smaller counties, it's less likely that they're going to look at it as at a woman as being actually guilty of it.
I
Yeah.
see. And then what about, Arnold, have you noticed substance abuse having an impact or relationship to domestic battery in any way?
I I believe so. Yes. So when people use alcohol, that could cause domestic battery problems in the household. People are drinking and then they get violent when they drink alcohol, and that causes them to commit domestic battery. It happens by between both men and women do it. It's not just the men that are getting drunk and beating up their wives. It happens where women are going and drinking and then beating up their husbands. I've seen cases where women have been drank alcohol, become severely intoxicated, and in front of police officers ran over their husband's leg
Right.
with their car. It's
Oh, yeah.
definitely alcohol does cause bad things to happen.
What about orders of protection? How do they play into domestic battery?
So orders of protection, there's any protective order. There's three specific kinds. One is an order of protection that's meant specifically for family or household members. That would fall under, that definition of, the domestic arena. Then there's, say, stalking no contact orders. That's for, say, you know, Arnold and we got into a fight, and he is following me around, or he's threatening me and stuff like that. I can get a protective order against him for that. There's also one specifically meant for like sexual assault victims. But typically, when it comes to an order of protection, um, it's kind of quasi criminal, quasi civil, even though it falls under the civil rules of civil procedure. Oftentimes, the acts themselves could be criminal. So,
So
go ahead. Sorry, Arnold.
sorry. So with a lot of DV cases, the victims will automatically get durational orders of protection while the criminal case is going on. So if it's like a domestic battery, there's really not much that you can do to stop that. Ultimately, at the end, in order to get a plenary, it has to be something that the defendant agrees to, or there has to be a hearing on it. But once you pick up a domestic battery charge, then usually there will be a durational order of protection that will come with it. And if not, at the minimum, there will be conditions of release that will prevent the individuals from having contact with each other, unless
Arnold,
they want to amend those conditions and want to get back together, which happens a lot.
Arnold. So what happens if there's an order of protection against a spouse, and he's not supposed to go back to the house? Is that something that's common?
Oh yeah, it happens a lot, and people try to get around it by sending gifts. Like sometimes there'll be two people that get involved in a domestic battery altercation. They have children with each other. The children end up being on the order, and then they'll go and like buy something from Amazon to try to get around the order and mail something to the house. And there's so many different ways that they commit violations of the orders. It's something that happens often.
So what you're saying is, if a man or woman is charged with domestic battery and has an order of protection against them, they can't even buy flowers for their spouse?
They cannot send flowers. A lot of people try to leave them by the ledge and say, "Come back, I love you," like that song, "Baby Come Back." But the only place the defendant will be going back to is jail. So they
Okay.
have to.
So what other things would be violations? Well, let me ask you this different question. So what if the spouse says, "Hey, come on over, let's make up," right? Is that a
No,
violation
no.
of an order of protection if they come over?
Yes.
Even if the spouse doesn't want to proceed on the violation of an order of protection, sometimes the state will still proceed because it's a violation of the law.
And the way, again, they look at it as there's a reason that they are changing their mind. There's somebody influencing them, things like that. And they can proceed whether or not the victim actually does want it to testify. I mean, at the end of the day, these work one way. So in your analogy, so say, the spouse has an order of protection against her husband or whatever, right? she could walk up to his house, pound on the door, right? He answers, or he's within a certain foot range of it. She calls the police. He's in violation of it. So they only work one way. So again, how far that would actually go in a prosecution, that varies. But the police really wouldn't have discretion at that point because you're in violation of the order. You're a technical violation of it.
So what advice do you have for people that have an order of protection against them?
Do nothing. Don't talk. Don't smile. Don't look. Don't call. Don't send smoke signals. Don't send a carrier pigeon. Don't send your brother-in-law over there to talk to them on behalf. Because that's another thing. People often forget that third-party communication is also prohibited. So if I always try to err on the side of caution, don't say anything to a third party who may also have contact with the protected person in any way, shape, or form that could reasonably be addressing the situation at hand. Because it is so much harder to fight it from behind than it is to just prevent it on the front end.
I recently was communicated with by someone who had something on his phone that would go out as a reminder to his spouse of an event they planned on going to. So it was supposed to be a message automatically sent out that was a reminder to both of them. And the reminder went out, and he had an order of protection against them, and they put a violation against him because the reminder went out, even though he had activated the reminder to go out before the order of protection was ever entered. And they considered it a violation that this reminder went because he was not supposed to communicate with her.
So I had one not too long ago where there was an order of protection in place. The the victim alleged that there was a violation, that a cake was left for the petitioner, and there was also allegedly the petitioner saw our client walking down the street, right? So they filed the violation of it. Now, the petitioner also filed an extension on it to have.
Excuse me. A petitioner is in a order of protection. The parties' names kind of change, right? So one party's the petitioner and one party's a respondent. It's not defendant anymore.
Correct.
Right?
So the petitioner is the one taking out the OP on someone. Respondent is the one not responding. So what ended up happening at the extension hearing, we went to the extension hearing, and the judge found that sending a cake over to this individual, which you had pre-ordered before the order of protection actually went into place, and walking down a public street in River North wasn't a violation of the order, and it wasn't enough to extend it. So then when the criminal case came back up, I made it known to the judge and the state of what had actually occurred. And the state ended up dropping everything because the petitioner in that one and the victim in the criminal case forgot to tell them that small little tidbit about the basis for their violation was already decided at a lower burden to not be a violation. So again, when it comes to and it's so subjective, it really is, to like what is reasonable and what would be a violation, because if you're looking at it,
well, that's subjective though, isn't it, to the judge, right?
It absolutely, and to the individual too, because there are some people who would think flowers on the doorstep is heinous and it's harassing and it's abusive. Then there's other individuals who would do that, and a petitioner would be like, okay, whatever. My world's not really screwed up by this. Like, should he be doing it? No. But is my world going to end because he did this? No. So it's extremely fact specific, and also what they would allege in the order of protection as well.
So I wanted to ask you, because there's two things we're talking about at this time. One is domestic battery law, and the other is orders of protection. They're interrelated because they often go on at the same time, correct?
Yes.
Okay. Now, the domestic battery is a criminal offense that has a burden of proof beyond a reasonable doubt. Is that accurate?
Correct.
Yes.
So, what is the burden of proof in a violation of an order of protection?
So the violation itself, since the violation is a crime, so if they wanted to, find a person or go to trial on a violation of an order of protection, it would still be that burden of beyond a reasonable doubt. To get the order of protection itself, it's more likely than not, 51%, 50 plus 1, that something did occur that, this, order is necessary to prevent future abuse. And, I think we should also draw a distinction between emergency and plenary, because those are two very different things. When it comes to an emergency, they're done in secret. The respondent isn't required to be given notice. Okay, they're not really there to present anything, exculpatory testimony or evidence. And for the most part, the judges will go, "Is everything in this petition still accurate?" Yes. Okay. Here's your emergency, and then after that, the plenary is when you have the option to actually present a defense against it. So
it seems a lot of judges are more willing to grant the first one because it's temporary, right?
technically, yes. However, there are time limits in the IDVA when it comes to when a hearing actually needs to be held. But you have a situation, for instance, Bridgeview, right? Last week we were setting hearings in Bridgeview, and the earliest one they had was August. So technically they're temporary, but it depends on the county. It could be a year before you actually get to a plenary hearing. They're just how backed up they are.
So I heard of a case where a guy's girlfriend was calling his wife, and it was upsetting the family. And the guy and his lawyer went to court, and they got an order of protection to stop her from calling the wife. And the judge granted that. And then it was up for a permanent order. And the guy who got the initial order of protection to get the woman to stop calling wanted the order modified where he could still have sex with the other woman, right? But she still couldn't call his wife. So, the attorney told me he wasn't going to argue that in front of the judge. Do you think that was wise?
Yes, that was probably a good idea. Yeah, no, that's one of those where you shouldn't do it. I'm telling you why you shouldn't. Can you sign this saying I told you shouldn't? And then you go ahead and do it. And okay, I told him.
Yeah, it's on you at that point.
Yeah, I mean it's insane. And I've seen judges give emergency orders of protection to individuals that really they're not alleging actual contact with the respondent. They looked at me weird. Like, okay, you were walking down Michigan Avenue and she's your ex, and they looked at you weird. Like what is that? But oftentimes they'll rubber stamp them. In my opinion, this is just my opinion alone, they err on the side of caution because they don't want to be the guy or the judge that said, no, I won't give you an order of protection, and then God forbid something happens to that person. Their idea is we'll put it into place. They'll have their chance later on down the road. The problem with that is that the consequences for even having an emergency order on you are extremely severe. I mean, it's not just the fact that you could violate them, but employers, all of it, they're going to see that an order of protection was entered against you. And they don't see facts, right? They don't see circumstances. They don't see the fact that, they were harassing me, and then they went and got one first and I didn't. They don't see that.
Well, that's something, right? People getting canceled again, right?
Yeah.
They didn't have a chance to defend themselves yet. It's always going to be out there because we have computers and things are always out there, whether they did it wrong or not.
Yeah.
Well, a lot of people deal with orders of protection and they think that it's going to go away, but it doesn't go away. The only way that you could really get rid of it is if you're with the petitioner and then you ask for the court to vacate it.
Okay.
And even in that sense, I had a case not too long ago where we were at trial. The victim didn't want to testify. The state still put on a trial. So, I mean, they can. Is it very hard for them to do it? Yes, but they can. And another thing that is very common that I've also noticed is that, first and foremost, police are not mediators. Okay. If there's a domestic situation or an argument or whatnot in a domestic setting and the police are called, someone's getting arrested. Okay. I mean, they're not going to come in there and say, oh, well, we can do this and then this. No, they're like, okay, you called us, something happened, we're arresting somebody. And then the victim afterwards will say, no, I just wanted him to stop yelling or I wanted him out of the house. It's like, but you called the police.
Yeah.
Like, yeah, but I wanted, it's like, well, the police aren't mediators, right? And in order of protection, the consequences of it, since even just having an emergency one against you, I mean, they're not an offensive weapon. And sometimes you do see that. You see.
So what you're saying is sometimes, like in a divorce situation, someone might use this as a tool to try and get the upper hand.
Yes, and just a lot in child custody as well, and others. When it comes to children being involved, it becomes murkier than the Chicago River. I mean, it's there's a lot of issues going on. You got a GAL coming in. You got all this other stuff going on, but oftentimes when a situation will get overblown, and you also see this too, where the respondent, I don't want to have anything to do with that person, right? I don't care. I'll tell them, it's like, no, you don't want to have a 2-year plenary order of protection against you because it's going to follow you. But I just want to get it over with, even when they may not have actually done anything wrong to warrant the order of protection. I mean, I've also had clients when they've come back, they've been out of the country. But when they come back through customs at O'Hare, they get smacked with the order of protection and served. And at that point, it's like, I can't go home now. Where do I go? What do I do? The law doesn't care at that point.
Right.
The only thing they care about is whether or not you're going to go home and violate it. I mean, they're just like, don't really care at this point.
There's almost a presumption of guilt.
There is. And again, that is the very dangerous part about this, is because facts are not conveyed, right? I mean, it's a one-sided affair when an emergency order is entered. And literally, I've seen some judges ask questions of petitioners. I've also seen judges, is everything fair and accurate in this? I mean, they may not have even fully read it, and they'll sign it. And that, that follows. I mean, that goes down the road. And, the first violation is a misdemeanor. The second one's a felony. So, it gets extremely murky on what exactly everybody's supposed to do.
People fight dirty sometimes, don't they?
Oh, absolutely. And what people also don't understand is, like I said, the police are not mediators. These are not meant to be a timeout in the relationship for 21 days and everybody is copacetic and fine after that. So no. I mean, the judges in the state are very reluctant to actually, allow an OP to be modified or a violation to be dismissed unless it's in person on the record. The judge is asking questions, all of it, because at that point it's CYA. Because nobody wants.
There's a clear purpose for the law. I think we all agree. It's just that, like most things, it's subject to abuse, and perhaps this law can be subject to abuse more than some others.
Yes, because think about it, when you're indicted, okay, that's when the case begins, right? For the most part, right? Then you start building up the defense, and the punishment will come at the end of it. With these, the punishment comes on the front end, and you're fighting from behind, trying to defend something that you may not have known existed until the day before, right? And it's like, sometimes for the most part, judges will allow a respondent to go into the home and get certain items like IDs, passports, clothes, things like that, right? Sometimes
But they would do that right with the police, right? The police would probably be there.
Yes, with a police escort. However, I've also seen situations where the petitioner removes certain items and prevents the respondent from taking what belongs to him. Now, we would have to, in order to get permission to go back, we would have to get the judge's permission in an order allowing and telling that the petitioner to return the items that apparently have gone missing, right? So it's not, and often the vindictive nature of these. No, I'm not saying at all that the purpose of the law is good and it is meant to, like you said, the spirit is good. It's meant to help, but it is subject to a level of abuse that, frankly, in my opinion, doesn't have any oversight, because until you have the plenary hearing a year after the emergency enters, you've got parents out of their kids' lives. You've got, people renting, an apartment and paying for a house, doing the same thing with cars and all of that. And it's like, the damage is already done. And when it comes to the emergency, that time is not counted against any plenary time. So an emergency could have been in effect for 9 months. That 9 months doesn't go into the 2 years of the plenary. So it would be 2 years, up to 2 years from the date the plenary is entered. So you're looking at
what you're saying is just, so basically a judge can enter an order of protection just on one person's word, and that order of protection can remain in effect for a year, even without a hearing?
Yes. And the IDVA said it's not supposed to go longer than 21 days. But there's leeway. There's leeway because, for instance, in Cook County, they don't have the time. The backlog. It's so great. You're getting, an emergency OP that was entered in September, set for hearing August the following year. But in like a smaller county that doesn't have the volume, you could go to a plenary on the actual day, the first court appearance. So there's definitely gamesmanship that is played in the larger counties, and that also the rules of civil procedure, having those being applicable, don't do anything to expedite the process.
No, because you have to subpoena your witnesses and your evidence, and that can all take months on the short end of the stick.
Yep.
So, I get that. Gentlemen, I thank you both, Arnold and Paul. You're true gentlemen. And I'd like to thank the Hirsch Law Group for having you here today.
Well, thank you very much.
Thank you for inviting us.
I hope you guys will come back and join us again. And for now, we're signing off from Win with the Law, and thank you for joining us for another episode.
You've been tuning into Win with the Law with your host, Gary Newland. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, newlandlaw.com. Thank you for your positive reviews, comments, questions, and for sharing this show with others.